Hello, everyone. I'm just going to ask you to mute yourselves before we get started.
But feel free to have your cameras on so that we can see some people if you like.
I'm just going to mute some people. Perfect. All right. To begin, let us acknowledge Queens is situated on the traditional Anishinaabe and Haudenosaunee territory. We're grateful to be able to live, learn, and play here on these lands. Thank you all for joining us this evening for the mock class. We're really excited to give you a taste of what it's like to be a JD student. With us tonight, we have Professor Lisa Kerr, who will be providing you with the lesson. Lisa teaches courses in criminal law, sentencing, and prison law, and she also serves on the criminal law group at Queen's Law. Lisa, I'll pass over to you.
Great. Well, thanks, Maggie, and good evening, everyone. It's great to see at least 5 of you and to see some names in other boxes. If anyone else wants to turn on camera, I do plan to kind of make this a bit of a conversation. So it's called a mock class, but I'm going to do the tiniest bit of a sample lesson, a portion of a sample lesson. But what I'd really love to do is just talk to you about any questions you might have. They could be questions about law school in general, about first year and what that is like and how to prepare for it. It could be questions about which law school to go to. I'll probably be pretty biased on that one, but I would be happy to talk to you about how to think about, questions of geography in terms of where you want to practice and live, and how does that impact where you might go to law school, that sort of thing. So I know it's a time in life when you have a lot of questions. So I'm more than happy to just make this mostly a conversation. I have already taught for almost 5 hours today. So we won't be doing any hardcore lecturing because my brain wouldn't have that capacity at this point in the evening. So as Maggie said, I teach criminal law. That's a mandatory first year class, right? That's kind of the hardest thing about first year is you don't have control over your curriculum. You're just put into the classes. It's a standard first year curriculum. And it's the theory behind that. And it maybe is sort of too old of a theory and one we need to revisit, but the theory behind it is that you get a foundation in all of the core legal subjects, right? And it's a mix of private law and public law. So my colleagues might not all designate things this way, but I think of, private law as about the law that applies to the relationships between citizens, between people. And I think of public law as the law that governs the relationship between people and the state. So I think of public law as including law about the Charter of Rights and Freedoms, law about our federal division of powers between the federal government and the provinces, and there's lots else in that package, and criminal law, right? Because criminal law is really about the relationship between citizens, between people in Canada and the state. And it's really one of the most intense and risky sort of encounters that an individual could have with the state in terms of what's at stake and the deprivation of liberty that they may be facing. And the prospect of punishment. So I'm kind of a public law person. Criminal law is a subject that tends to overlap with constitutional law. Obviously, we've all heard about the rights that you have as a person who's being detained by the police or being investigated or being prosecuted or being imprisoned. Those are the areas of law that I'm interested in. Some of it is criminal law, but it's also broader than that. It touches on administrative law and constitutional law. So first year gives you a grounding in these subjects. So the private law topics are torts, contracts, and property law. And I've mentioned the public law topics. So the challenge of first year is studying all that stuff simultaneously. It's hard to do. These are 5 huge topics, and you have to do them all at the same time. And, there isn't always a ton of overlap or synergy between these topics. And so that's the challenge of first year. And I always say that there will be no year in your life where your sort of trajectory of learning kind of goes like this. It starts like this at the beginning of first year, and then you're just zoop by the end of first year. And there'll never be another year of your life that's like zoop like that, right? You might like have a cool experience one year and go like this, or do a master's and go like that. But there's kind of nothing like first year. I mean, depends, of course, the knowledge you come into it with. But if you're anything like me, you didn't even know what the charter was. You didn't know what the word torts meant. You didn't have a lawyer in your family. You didn't know a judge. And if that's the background you're coming in with, right, where it's a really unfamiliar territory, then what you learn in first year is just super profound and exciting, right? Like, when in life do you have the zoop ever again, but it's part of the challenge. And I always say law school is 1 year long. We think it's 3 years, but it's really that first year that is the ultimate challenge. And after first year, you're kind of back in the driver's seat. You get to pick what classes you want to take in upper year, right? If you're drawn to social justice, if you're drawn to immigration law, if you come to Queen's because you want to work at the prison law clinic. I'm trying to name some private law stuff, but I can't. It's just not my thing. Other people will be able to help you with that. If that's what you want to focus on, by second year, you can do it, right? Pick your classes accordingly, sign up for a clinic experience, get a summer gig that's relevant in that area. And you're kind of, by second year, I think, entering the professional life of being a lawyer. That first year is the real tough one. And it's a pretty consequential year too, in terms of, your attitude towards law school, in terms of some of your academic trajectory and so on. So I also say to first years that in first year, it's very tempting to try to like do a ton extracurricular, right? Try to get a research position with a prof, sign up for this or that. I think it's a year to mostly just focus on studying. And so when I care about students, which is always, and they come to me and want an opportunity in that first year, want me to help them find it or offer it through research for me, I always kind of say, wait for second and third year, right? This is a time to just allow yourself to immerse. And it is more than hard enough to just do that. And of course, you're all coming with lives and families and other obligations as well. So that's kind of my spiel on first year. Anyone at the moment want to jump in with a question about any of that, or about Queen's or life, or anything about criminal law, whether the truckers really did commit a crime in Ottawa, whether they should have gotten bail? Those are the only things anyone wants to talk about with me lately. Okay, you can use the raise hand function if you're a video off person too, or throw it in the chat. If that's not happening, I'm going to pretend to do a little portion of a criminal law class. Okay, let's do it. So far, so good, everyone says. Okay, good. Or Madison says, I should say. All right. Okay, so I'll just give you a little taste of like 5 minutes in a first year criminal law class. So one of the ideas we start with in my class is talking about the criminal code. And my son happens to be lying on my bed reading it right now. Just playing with it. And it's interesting because he actually appears in my slides in a moment. So hang on and you will get a view of Henderson. Hang on, there he is. There's Dad. Okay. Okay, so yeah, and the sort of first step with criminal law is to understand that there's no such thing as a crime in Canada unless it is laid out in a provision in the criminal code. That's where you have to start every single time. We don't make it up as we go along. Judges do not have discretion in our legal system to designate on a case-by-case basis what is criminal conduct and what isn't. So that's sort of a foundational idea that we spend time on in the first month. All right. So the first case that I teach is from 1663. I like to just really get to the contemporary stuff that is on everyone's mind. So this is the first case I teach, R v. Sedley. What does the R stand for? It stands for, the sovereign. And these days it stands for the queen, but back in 1663, it actually stood for the king. These are the facts of the case. We brief cases, right? We read cases, which are, decided authorities, and we look at the facts and we see what the facts teach us about what the law is. 1 second, I gotta really send this child. Oh, his dad's here. There's hope for us. Okay. Bedtime. This is what you get when you ask people with young kids to do things at 7 p.m. All right, so these are the facts in R v. Sedley. Your D is defendant, sometimes say accused, sometimes say defendant, but this is what he's alleged to have done. This is in Covent Garden in London. He's in his flat, he goes out to the balcony and does this lewd stuff on the balcony. This is no good. He's clearly drunk. What's he up to here? The issue in the case, did the defendant act against the king's peace? Now, to a Canadian today, right, this should look pretty weird because there's really only one question in a criminal prosecution in our courts today, and that is, did the accused commit the offense alleged? And has the state, the Crown prosecutor, proven it beyond a reasonable doubt? And so this sort of amorphous notion of acting against the king's peace, right, really kind of offends our modern sensibilities. What does that mean? It sounds too broad. It sounds too ambiguous, right? If that's a crime, then there's so many things that we can just easily call a crime. And there are some offenses in the criminal code today that are a little vague. That's why we were having the conversation about whether the truckers actually committed a crime, because the crime people think they probably committed was against a crime of mischief, which in our code today is drafted in some fairly ambiguous, broad language. Procedural history, what's happened in the case so far? That's part of how you brief a case. Well, in this particular case, it's a guilty plea. He's not contesting the facts. In that way, this case is very much like a contemporary Canadian case, where the vast majority of our criminal cases are resolved by way of some kind of joint resolution, some kind of agreement, some kind of plea. So today in our criminal courts, most accused that are going in front of judges are going in front of them to say that they're guilty, right? The criminal trial is a fairly rare thing, statistically speaking, in our system, and they're going to go in front of the judge and be sentenced. And in our system, it could be a guilty plea with a joint position on sentence, right? Part of the agreement of the guilty plea is that the prosecutor won't ask for more than, let's say, 6 months. Other times the sentence is contested, but the accused is pleading guilty, and it would be a significant mitigating factor that they accepted responsibility and spared the state of the expense and uncertainty of a trial. So that's the procedural history of this case. Now, the disposition in this case was a fine, 1 week imprisonment, 3 years probation. What does probation mean back then? Well, that's a big historical question. But what's the legal rule that led to his guilty plea? It's the idea that profane actions can form the basis of conviction for offending against the king's peace. So in the negotiations around the plea, this guy knew he was going to be convicted of that offense, part of what went into his guilty plea. And yet we still don't really know what his offense is. He's done something kind of naughty and gross. He's been drunk. He's caused a disturbance of some kind, right? But what is this offense? What are the elements of the offense? And I'll compare it to an offense that all of us know very well, a contemporary offense, the offense of assault. If you look at section 265 in the criminal code, it lays out the offense of assault. And what does a prosecutor, what does the state have to prove in order to convict someone of assault? Well, they have to prove a number of act elements, sometimes called the actus reus, if you still like Latin. And there it is, the application of force in the absence of consent. If you do those actions, you apply force to another human being and you did not have their consent, you have committed the act element of assault. So very clear what you need to do in order to commit an assault. It's not, profane actions against the bodily integrity of another person, right? No, it's the application of force without consent. What's the mental element? There's always an act element and a mental element with a crime, the mens rea. The application of force has to be intentional. So if you just tripped across a chair and landed your body on another person, that's not intentional. That would be what's called an accident rather than a crime. And you have to have knowledge of the absence of consent. So you have to know this person has not consented. So Section 265 of the Criminal Code lays out the elements of the offense. The Crown Prosecutor knows what she has to prove in order to get a conviction. And Canadians can read that provision and know what the crime of assault is. But this is back in the day. And back in the day, we just let judges do it one case at a time. So he's convicted, he's got his guilty plea, he's convicted, his profane actions committed against all modesty. He neglected Christianity and morality. Naughty, naughty, you're convicted. And his sentence, though, they give him a bit of a privilege discount. You're from an ancient family, so we'll give you a little discount. And we want to induce your reformation rather than ruin. Would that happen today? Well, I think actually social privilege does impact sentencing quite a bit today. I don't think we would do it so explicitly. Well, I know we wouldn't. We would not. But I do think that when an accused comes before a judge today and they're able to say, I was working when this happened, I finished college, I'm married, I have good supports, right? If they're living a life of sort of middle-class respectability and they're sort of engaged in pro-social activity, that can help a lot at sentencing. And yet we also know that those kinds of features of your life can flow from privilege and advantage, opportunity that a great many people who appear in provincial court in this country have not had access to. So we don't do an explicit, sentencing discount because you're from a good family anymore, but these things can happen in informal ways. Now, this is not how things work today. Today, R.V. Sedley is what we would call bad law. It is not the law. You can't just refer to some general notion of profane actions against all of Christianity and morality, therefore naughty, naughty, convicted of an offense against the king's peace. We don't do that anymore. There's no such thing as a common law, a judge-made offense in Canada. And that's codified in the code in Section 9, notwithstanding anything in this act or any other act. That's basically saying no matter what, no person shall be convicted of an offense at common law. And that is, I think, a real accomplishment of the society, that we've stopped just allowing powerful figures like judges to decide on a case-by-case basis whether they think someone has committed misconduct worthy of criminal punishment. Now we at least require Parliament, and it is a federal jurisdiction, it's a federal matter, criminal law. So we're really talking about the guys in Ottawa. It's up to Parliament to pass criminal offenses, and they do it with a great deal of regularity. The Criminal Code is a piece of legislation that gets a lot of attention. It's very politicized. It has to do with people's safety, with vulnerability, with sexual integrity, with physical autonomy, these kinds of things, with the protection of property law, morality offenses, if you think of drug offenses and sex work and so on. So there's a lot that gets a lot of political and social attention that goes into the criminal code. But the first thing I sort of teach my students is that you don't get to make it up as you go along. It has to be a provision in the code in order for a criminal prosecution to take place. And at this point, I would open up the class to discussion. And I would the rationale for that be? Why would we want? Oh, and there's my son, Henderson, you're in this slide, buddy. I was mentioning all the social and political attention that the criminal code has received, and that's part of why it's so huge. It's my son picks it up and he called it the infinity page book. He just cannot believe that I have to deal with this thing on a daily basis in my career. So he loves flipping through it. I think he just finds it to be really quite bananas how long it is. We've done a really bad job of like cleaning it up over the years. We just add stuff and add stuff and add stuff. And it's a fairly complicated text that keeps criminal lawyers and people like me in business. So in terms of the rationale, why insist on codification for criminal offenses? So at this point in a law school class, you know, you're on the edge of your seat because you know the prof's about to call on you. And there is a little bit of a practice of cold calling. I'm not going to do it to any of you because I want you to like me. But, you know, at this moment, your prof could just say your name and say, you know, why would we want that? But there's usually been a bit of a hint in the lecture already. And I think I've already given a little bit of a hint too. And it had, I don't know if anyone, does anyone want to? I operate on a sort of voluntary participation model. Does anyone want to jump in there with why we would want to insist on codification? And then the thing is, when you put your hand up, you have a little conversation. Laura, what's up?
I was just going to say, maybe it keeps things like standardized so that it keeps like, kind of the law the most fair, so that everyone's kind of getting the same treatment by using the codification kind of form.
That's a great point, Laura. And it really, you know, like the judge that thought throwing urine in bottles over a balcony did offend the king's peace. You know, the next day you might get the judge who thinks that's hilarious. And it's not a crime at all. And so Laura's absolutely right. It's this problem. I mean, maybe all the judges in 1663 would have convicted this guy, but there are other cases that are much closer to the line, right? And if we think of our truckers in Ottawa, you know, whether that is an offense against the king's peace, the queen's peace now, right? That would be possibly hard to adjudicate and could really depend on the judge that you drew, right? Probably not in Ottawa. If the judges could hear the honking, then you're probably convicted. But you could, let's say you could get a judge from Calgary. you might have a shot at acquittal if the offense was simply a common law notion of offending against the queen's peace. Right? You might say, not only was I not offending against the queen's peace, I was out there pursuing the very freedoms and liberties, right, that this country is founded on. You know, certainly not profane to fight for the freedoms of the unvaccinated, right? That would be the pitch. So we want standardization. We want fairness across cases. We want equality in how the criminal law is administered, right? And you can bet that I always say that in the criminal justice system, there are many points of discretion. Discretion means someone who gets to kind of decide for themselves, right? Where there isn't a black and white rule. And there's discretion that police have, whether they're going to pull you over at all, whether they're going to try to investigate, whether they're going to arrest, right? Whether they're going to consent to pretrial release from the station or have you do a contested bail hearing. What is the Crown going to consent to bail? Is the Crown going to proceed with these charges? Is the Crown going to proceed with charges that have a mandatory minimum attached? There's so many discretionary decisions that get made already. And I always say with each point of discretion, there's the prospect of the decision maker smuggling in considerations of race, considerations of class, considerations of gender, right? Even, and when we understand how unconscious bias works, right, it might not even be really known to them, the ways in which that was affecting their decision making. So discretion is a problem in the criminal justice system. Discretion is also essential in the criminal justice system. And as often as not, I think Crown prosecutors are using their discretion in order to ameliorate the effects of the system and to show mercy and to decline to prosecute where the public interest doesn't call for it. So discretion is an important thing, but anytime you have it, it gives rise to the possible inequality, the sort of variable administration. So Laura's was so good, I didn't even have it on my list. I got to add it, but there are a couple others. Anyone else want to jump in? What else would we be worried about if, in order to know what's a crime, you have to like go to law school or go on CanLII and just like keep on top of the Ontario Court of Appeal jurisprudence, which even I hardly do, and I teach in this area. What would be the problem with that? If that were what it took to know the criminal law? If that's what it took to know what an offense is, Talia, and then I'll get Kendra after that.
I guess if people are ignorant, they could commit a crime without knowing.
So Talia, that's the point I was going for, a point around notice, right? Fair notice. But let me just ask you a follow-up question, Talia. So unmute again. If someone is ignorant of the law, is that a defense? Can they say that as a defense? Well, you know, I didn't know. And, you know, the truckers have said, I'm really picking on them. I wasn't even planning to mention my truckers in Ottawa, but they're very helpful right now. This is the thing, the headlines kind of seep into your criminal law teaching a lot. A lot of the truckers seem to be saying, oh, I didn't know any of this was a crime. You know, it's their first time protesting. They didn't go to any of this stuff before. They thought there was a right to protest in Canada. Is that going to matter, Talia, in their criminal prosecution, do you think? Maybe you're just guessing, but what's your guess?
I would say no, especially with the way we have it now. I think what I was getting at more is that if it took too much effort to learn the laws, people wouldn't attempt to do so, which could result in increased ignorance, I guess, if that makes sense.
Sure. So it's about enabling, you know, making it possible to know the law. Right? It needs to exist in a single coherent, readable source, right? You can readily knowable source. So it's about fair notice, but I mean, let's face it. Have we all read the criminal code? I haven't even read all of it or even really half of it. You know, sure, that's the idea behind this rule, but it's also the case that you know, there's lots that we don't know about what's in there, and that is not a defense. Defense of law, mistake of law is not a defense in our system. That it does not matter. And it comes up actually a lot in the sexual assault context. So under the modern law of sexual assault, since we went through a really significant period, I'm coming back to you, Kendra, so don't give up. In the modern era, we have a notion of consent that requires affirmative communicated consent by words or action. So if an accused in a sexual assault case, and this did happen for a long time, said, you know, I thought she, and these are very gendered cases, I thought she was into it, right? I had no mens rea about the absence of consent. And, you know, what's your evidence? Well, you know, she didn't say no. And if that's your view, well, no one has to say no, right? You have to obtain affirmative consent. Otherwise, you are at risk of having committed a sexual assault, because passivity is not consent. There's no such thing as implied consent. So you may have a misunderstanding of the law and what is legally required in terms of affirmative communicated consent, but that is no defense. you could still be convicted, and people have been convicted. So yes, it's about fair notice, but does everyone read the criminal code all the time? No. Kendra, do you want to come back, or did I steal your point from you?
No, I was just going to say, going back to what you were saying about privilege, I think another reason for codification of criminal offenses could be that not everybody is in a privileged position if it's not accessible. I mean, you know, internet hasn't been around for that long. We can't access it that way, but even having physical sources is one way of making sure that people who don't have social connections, say, like if you don't know a judge or you don't know a lawyer, that there's still some means for you to access the law and get informed and obtain that knowledge.
It's a great point, Kendra. It would simply be too unfair, even though we know not a lot of us are reading the criminal code. It would be simply too unfair for you to like have to have an advanced jurisprudence degree in order to know when the state might come knocking at your door with the threat of criminal prosecution and punishment. So it's a kind of theoretical thing, but it's an important theoretical point. Fiona.
It also is really great in preventing like abuses of power from those in positions of authority. And I'm mainly thinking about like the Code of Hammurabi and like how that fundamentally challenged like the government's ability to unleash certain either death threat or like death penalties or certain other punishments for the crime. And that just fundamentally shifted so the government couldn't abuse its power and kind of attack certain subgroups within the law.
Absolutely. And that really is a great point, Fiona. It's the point about the rule of law. And that when you truly live in a rule of law society, it is a great constraint on state power, right? Because the state can only act in accordance with their laws. Now, you know, the state can change the law unless it raises a constitutional issue, right? The Constitution kind of limits the ability of lawmakers to change the law on certain things, but the Constitution is, you know, really just at the boundaries. But absolutely. So, you know, part of why, I'll go back to Ottawa, part of why the federal government had to invoke the Emergencies Act, I think, you know, there might be more to this story that we'll learn more about as time goes on, but it seemed to be that their existing legal authority to do things like freeze bank accounts was absent. And they didn't have that existing legal authority, so they needed to invoke this sort of extraordinary act in order to be able to do that. And part of why people were reacting to the invocation of the Emergency Act is exactly Fiona's point, that the state is supposed to work with the law as it is. And if the state wants to pass legislation to give itself new powers, well, fine, but this didn't go through that legislative process. Yeah, and in criminal law, it's really important because something happens, right? And it really provokes a lot of public passion. And in those kinds of cases, it becomes more important than ever to stick to the letter of the law, right? And all right. And avoid discretion, right? Legitimacy problems with individual judges being able to go on a case-by-case basis, possibly smuggling in discriminatory notions and so on. Now here's the big, so this is what we do in law school. We're like, okay, here's the thing, here's the law, here's the rule, here's the case. What's the rationale for it? We're always looking at the underpinning. And then we're like criticizing those rationales. Well, do we actually live up to those? My scholarship is really informed by sort of law and society approaches, which are always interested in the gap between the law and the books and the law and action, which is sort of a way of saying, what are the formal official narratives that we tell about law, right? And then what's the reality, right? And there's often a huge distance between those two things. I work on sentencing and on prison law specifically. And, you know, we tell a lot of fancy stories in sentencing courts about what it is that we're pursuing in terms of the aims of punishment, right? We want to go after rehabilitation. We want deterrence. We want public safety. We want restitution. And the reality is that when you're just sending folks into jail and prison, right, whether those purposes are actually pursued in the correctional context, right, I mean, the legal system doesn't really pay any attention at all to that. So we have this official narrative at sentencing, and then a huge gap in terms of the realities of the administration of punishment, the experiences and effects of it. So I don't know if there's anything else on here. Oh, well, I had some other stuff. I'll stop there. I'm going to stop my share, turn you guys big again. So anything else that you guys want to talk about? More about that topic, more about what you're thinking in terms of law school heading into first year?
I guess I have a question, but it's a bit more
Go ahead,
related to
Nina.
the lecture. So why have we decided to codify criminal law, but a lot of other aspects of law have been kind of left up to interpretation? Like torts law has all of these tests, and then in civil law, it's just kind of one guy versus another, but you get lawyers to duke it out in front of the judge. So like, why has criminal law been the one to be decided, kind of so strictly codified?
It's a great question, Nina, and it's one that allows us to talk a little bit more about, what's distinct about criminal law. In first year, I always have to kind of remind my students, listen, your other classes are very common law classes in first year. Property, torts, contracts. Constitutional, you got to look at the constitutional text, obviously, but in most other first year classes, you're looking at the common law. You're looking at judge-made decisions. You're very rarely looking at legislation in these other classes. And I think at first students don't tend to like legislation. It's kind of hard to read. It's sort of awkward. Like you came to law school thinking like, I'm going to read judicial opinions. That's what this is. Stare decisis, right? That's what we're doing. And then in criminal law, I always have to tell my students, like, you got to start with the code every single time. There's no such thing as a crime without a provision in the code. That's where we start. And if you try to answer a fact pattern exam about a murder and you don't mention the provisions in the code that govern murder, right? This is a big problem. And every year I'll have students who just try to do it using the case law. And it's a big problem. So it's distinct. Nina's absolutely right. It's distinct. There'll be other classes coming later where it's a lot more legislation heavy, but in these foundational topics, you start with the code, but you start with the code just for the offense. There's a heck of a lot of judge-made law in the criminal law field. The courts have to interpret the code provisions, right? There are a couple of sentences, right? Each provision. The court has had to figure out, what does that mean? How does that apply to these facts? Defenses are still common law. That was the next slide that I cut off at, was talking about how defenses can still be developed through the common law. So self-defense, provocation, duress, whatever you're trying to advance, that can be judge-made. So there's a heck of a lot of like judicial activity that tells us how the criminal law works in Canada. But when you're talking about the offense, the wrong itself, it has to start with the code. And I really think the main justification for that is that this is the most severe thing that a state can do to a person. It is when the state is a Leviathan and it's coming at you when you are charged with a crime, and all of the resources are on the side of the state. The state has the police, the state has salaried prosecutors, right? The judges are part of the apparatus of the state, even though they are independent, right? You got this whole thing against you, and you have one person in our system who is standing in the way of all those people coming at you. And that's defense counsel, right? And they may or not be paid by legal aid, depending on your income. It's very low, very hard to get legal aid, right? You have to be, you can't make much money or have much money to get it. And I think just it's an idea of fairness that the state should not be able to deploy all of its resources against you if it hasn't named in advance the wrong that you are accused of, that it shouldn't get to make that up as it goes along, right? And those truckers, they definitely, you know, like we might all agree, and maybe we don't all agree, but a lot of Canadians think what they were doing was wrong. But that sentiment, that broad public sentiment should not inform whether they wind up convicted of a crime, right? There's a difference between social morality and a criminal wrong. And there should be a vast difference between that. And, you know, the way I raise my sons, I teach them to be a lot better than just don't commit any criminal offenses, right? I'm trying to have the bar be quite a bit higher than don't violate the criminal code, right? Because there's being a decent person and a good neighbor and, you know, making the world a better place. And there's a huge distance between that and a criminal wrong. And that's just as it should be. And no one should face the state coming at you unless the state named in advance that this could be the basis for criminal liability. And then the Crown prosecutor should have to prove the elements of the offense. That's the map that constrains the prosecutor, right? And it's tough to convict someone of a crime in a trial. It's really tough. They got a lot going against them, actually, this Leviathan state, because we have a lot of important rules that protect defendants in our system at this point in our history. Fiona, go ahead. Oh, maybe Fiona's chatting with someone else at the moment. No, you okay?
Hi, sorry. I was just wondering if you could give like a basic breakdown of like class structure and maybe like assignments, or how you maybe yourself pose the course throughout the semester or year, however long it is, just so we know what to expect in terms of assignments and tests and exams.
Yeah, so there's a bit of a shameful thing at law school that we don't really do a lot of assignments. Maybe some of my colleagues do it a little differently, but in first year, we're pretty old fashioned. Like we have your December exam, which counts for like 10%. So it's not a big thing. And we have the final exam. Now I might do a little thing here and there in the semester, like, okay, next class, you have for crowns and you have for defense, show up with your best argument about how to appeal the case we're reading. But that's like a sort of informal way to just like help you engage with the materials. I am not grading that. I'm not giving you a grade back for that. Like, you know, you have to really take responsibility for your learning in law school, because there are huge exams at the end. And there isn't a good ability. My partner teaches in philosophy, and he's constantly grading assignments and exercises and these things. And it's like 10%, 20%, 10%, 20%. And he has TAs. So that's the one advantage he has that I don't have. But that's not really how we do it in law school. It's big final exams. And so you really got to buckle your seatbelt and stay in control, because, you know, everything hinges on these exams. And we have big debates about whether we should change that. And there may be some courses that are kind of moving forward and breaking things down. But for me, December exam, final exam. And I do give a participation grade. I just find it enables me to do a little bit of a personalized thing to someone's grade. We do anonymous grading at law school. And for me, I find it kind of painful. I get to know people. It's fair. It's definitely fair. But I get to know people really well over 9 months. I can see whether they're devoted to the class, whether they showed up prepared, all these things. And that doesn't always, usually, but doesn't always get reflected in their exam outcome. And so with the participation grades, I'm able to like jack someone up because of what an awesome person they were in the room. I never use it as punishment. I only use it as a way of jacking a few people's grades up. So does that answer what you were asking? All right, so Sam.
Hi, I was just wondering to what extent we'd have to memorize the criminal code for things like exam, or if we're given the code
scary.
Like as a help, like we have a copy or something there, or if we're supposed to memorize assault.
Not only do you not have to memorize the criminal code, you don't have to memorize anything. we have a deep tradition of open book exams in law school. You can bring in your notes, you can bring in the code, you can bring in your textbook, you can bring in whatever you want in written form, right? The only thing you can't do is talk to any of your fellow students while you're doing your exam, or look on the internet for anything. Not that it would help you. We write really distinctive, weird fact patterns that are impossible for anyone to assist you with. So yeah, there's no need to memorize the code as if, I mean, I could never do that. I have a handful of provisions memorized that I just have had to go to so many times. But what you do need to know how to do is just work with the code, right? But in first year, I don't expect that much advanced. Like everything I teach that's important from the code goes into a slide. I share all my PowerPoint slides. So I feel, you know, the PowerPoints are kind of there as a study aid at the end. If there's some really crucial code provisions, we will have worked with them extensively in the class throughout the year, right? If an exam is asking you to interpret or apply a code provision that you haven't seen before, I would reproduce it in its entirety in the exam. I don't want anyone spending their time, you know, parsing, you know, flipping through the 9,000 page criminal code while you're trying to write an exam. So there's no trickery like that. You know, we're really trying to teach you how to be lawyers, and lawyers don't have to have anything memorized. What lawyers have to be able to do is very quickly access information and have good background understanding of the legal area. Okay, guys, well, are you sure no other questions? Oh, Michael, what's up? Oh, muted.
All right. Yeah,
Hey.
I wanted to ask, like, if someone is preparing to go there, and maybe is there something like a syllabus, or because I've been trying to Google like books and stuff like that. I thought that would be helpful for me in the summer here before I make the decision and see maybe a book that might feature a syllabus, something like that, and you know, get to acquaint myself with the material.
Oh, Michael, I know students like you, right? You're wanting to get ahead of the ball a little bit, right? You're like, I got to prepare myself for this. Yeah, I know what you mean. Well, yeah, I mean, if you want my syllabus, send me an email, I'll flip it back to you, no problem. But, you know,
Yeah.
It would be pretty hard to just like sit down and start working your way through a syllabus on your own. And, you know, there's no prior knowledge required. There really isn't. I mean, if anything, I would read a book about like the design of the Canadian political system, right? Like I think background knowledge about the levels of government in Canada, their various responsibilities, like just a really good understanding of the political system would be good. But I mean, you know, the first year curriculum is designed to take you from zero.
The field is pretty intimidating, so that's why I feel like, you know, before it tackles me, let me
Totally.
let me do something about it. Yeah.
There are these. Do I have one sitting right here? Oh yeah, I do.
I'll try to email you. I'll email you definitely.
Yeah, you go ahead. I can give you a syllabus, but my syllabus is not going to be what you need.
Okay.
There are there are all kinds of books like Introduction to the Canadian Legal System. That's what I would do. Like I wouldn't start trying to read cases or code provisions the way I would do with you in class. I would read like, you know, almost undergraduate political science textbooks that especially if your undergraduate degree is like science or fine arts,
Yeah.
And you just haven't had the opportunity to kind of do the design of the Canadian political and legal system. So yeah,
Yeah.
introduction to the Canadian legal system. The Irwin Law has the essentials of Canadian law. I'm teaching evidence for the first time right now. And so I remember when I was in law school, this was on my bedside table and I would clutch it around. And now I'm clutching it again, even though I graduated 15 years ago, because I'm teaching a new subject. But there's lots like that, but like, and Michael, like I'm sure you do this already, but when you're reading the newspaper and you see the Supreme Court of Canada has done something, just like really start tending to that. Go look up the case. Another cool thing you can do, you can watch cases get argued at the Supreme Court of Canada. They're all webcast now.
Yeah, I did try to watch some a few years back.
Oh, cool.
Yeah,
I love that. When I was in law school, they didn't have those. It wasn't webcast. It only started in 2010. So we didn't have that, but I use it all the time in the classroom now. Like I'm teaching a case and if it's newer than 2010, then it'll be the webcast. And I'll queue up a few good clips where the lawyers are arguing with the judges about the issue. Students love this, right? It's so much cooler to see something get argued and to see people struggling with how the law should be instead of just reading it in this cold, complicated page, right?
yeah.
So I like watching cases get argued. Go to the Ontario Court of Appeal if you have a free day. I don't know if they're back to in person yet, but
I'm in Ottawa. I did.
Oh, nice.
I went to the one on Elgin. There's a court on Elgin. I used to go there and see what's going on inside there.
That's awesome.
Yeah.
You sound like you're doing all the right stuff.
But it doesn't feel enough.
Yeah.
Yeah.
Well, trust me, when you get to law school, it'll feel like you're doing enough. That feeling will be gone.
Yeah. Oh, yeah, that's what I wanted to ask. But I'll send an email to for stuff I'm thinking about.
For sure. Happy to talk with you more.
Thank you.
Oh, how can we watch cases? Shayla asked. So if you just go to Google Supreme Court of Canada, and you can click on like cases. And it's hard to know if you don't know where to start, right? But any case, you can look at like 2022 cases. And if you click on that, it'll give you the factums, like which are the written briefs that the parties filed. And you can click on the webcast and you can watch it get argued. So maybe there's a case that was of interest to you. Now, this is Supreme Court of Canada. So this stuff is pretty high level. But it's a good way to get a sense of, like whether you'd be interested in courtroom work and litigation. Great. Shayla's going to be binging on the Supreme Court of Canada webcast for the next, forget Netflix, you guys. This is where it's at. Awesome. Well, we are nearing the end of our time. So it was great chatting with some of you. And let me know for sure if you wind up at Queens in the fall that you are here in this session, and let me know how you're doing. Sound good, Maggie?
Thank you so much.
Thank you, guys.
Thank you so much,
Thank you
Lisa.
so much.
Okay.
Thank you so
Bye,
much.
everyone. Nice to meet you.
Stacia, I don't know if you're there. I'm going to end the meeting. Bye.